issue that the board, legal framework, is how, if at all, may a legal non-conforming use that has been established some 60 years ago change over time, or may it change? The answer to that is that a legal non-conforming use, the case law, has developed since the 1940s. Legal non-conforming use may permissibly intensify, but may not expand or extend. There's a number of cases about the difference between an intensification and an expansion, some of which have been mentioned by all the lawyers who have spoken today, spoken during this hearing. As an example of a permitted intensification, there's a famous case, which I don't think any of the lawyers mentioned, involving the old Baltimore Stadium. It was built in the 20s. Zoning came to Baltimore in 1931, much earlier than King County. Prior to 1931, the stadium was used only by amateurs to play football and some other, I think they had some, drum and bugle corps kinds of things, and maybe some flag raising, those sorts of things. After 1931, the stadium was, as I recall, expanded. They added lights. And then in the 40s, Memorial Stadium, which is where the baseball team played, burned down. And the professional baseball team wanted to play at Baltimore Stadium, where only amateurs had played football, and infrequently. And the Baltimore City Department of Parks and Recreation said, okay, we're going to lease it to the professional baseball team. And the neighbors objected. They said that's an improper expansion or extension of the legal non-conforming use, which was for amateurs, it was infrequent, it was only for football and then occasional civic events. And now you're going to have professional baseball players there all the time, and you can't do that. Well, that's not what the Court of Appeals said. The Court of Appeals held that the use was substantially the same in sports. The fact that the participants are being paid rather than appearing voluntarily and amateur and being amateurs was not determinative. Though the use would be more frequent, and the crowds might be bigger, and the players were being paid, it was substantially the same use, and it was a permitted intensification. Finally, and this is really where I'll stop laying out the legal framework, because this is really what the board needs to do tonight, and that is, in addition to determining whether there was a use on the property in 1962 and how it may have changed, evolved, those are the right words, by November of 1969, the board needs to consider what was the character of that use, and what would be substantial, that is what has been going on the last year or two with Minary Street Alliance, substantially similar to that use, and does it qualify as a permitted intensification? That's for the board to decide, not me.
Since 1962, those 60-some years, there has been no criticism, no legal action taken against the American Legion for activities that were done on the property, which further complicates issues. There's been no legal clarity as to what was going on, what is acceptable. So it's up to us to take the testimony that has been presented to us and try and better understand what was going on in 1962 and how that evolved from 62 at least to 69. And if those same services are still being provided by the American Legion property, or those same activities are being used on the property today, and whether or not those uses have expanded or intensified, or have the potential to expand or intensify. So in 1962, Mr. Dillard testified as a adult teacher, well-respected teacher within our community at the time, that he was a member and the organization was providing public service in the manner of meetings, providing the facility for other nonprofit organizations to provide their services. They were providing a meeting place for organizations within the community. They were providing funding for services that were rendered off-site. Mr. Hill, do you have any other?
Well, I think Mr. Dillard was testified in 62 that when it came to blood drives, family community support, fundraising, resident facilities, and American Legion business meetings were continued, and they still are today. The building is being used.
I found, looked at the American Legion mission statement, to enhance the well-being of America's veterans, their families, their military, and their communities by their devotion to mutual helpfulness. Now, what is mutual helpfulness? Is that the Legion helping Minary's?
Two in front of us, so, I know some people are gonna be unhappy, some people are gonna be sad. It's just part of it. Nobody likes to be in that position, nobody. But here we sit. And because they let it go for 60 years, and we've got to make the decision. So this is based on, we talked from 62, 69, and other things that we discussed. I make the motion that American Legion located on American Legion Road is not abandoned its non-conforming use based on the testimony that we have heard on the property.
I second that.
All in favor?
Aye.
Right, now, we need a motion to establish that the use is or is not legally non-conforming. And I, in the final decision, then you will read and approve, which will become the official decision from which an appeal may lie. I can fill in your discussions about the scope of it, but I think we need a conclusion as to whether or not proof has been adequate in your view to establish that it's legally non-conforming.
I'll make a motion that the Legion has maintained its legal non-conformity.
Well, you might be that the American Legion's use of the property has been established as legally non-conforming.
The American Legion's use of the property has been established as legally non-conforming.
Second.
All those in favor? Aye. Motion passed.
So, do we have any further business that we need to address?
I need to sign this closed session form.
Make a motion to.
Second.
All those in favor?
Aye.
Meeting is adjourned.